Hello, welcome to this video where we're gonna go through together about a law that was voted in Rwanda in October 15th of 2021. Official Gazette number special of 15 October 2021, year 60. Official Gazette number special of 15 October 2021. Law relating to the protection of personal data and privacy. Law number 058/2021 of 13th October 2021 relating to the protection of personal data and privacy. Table of content. Chapter 1. General provisions. Article 1. Purpose of this law. Article 2. Scope of this law. Article 3. Definitions. Chapter 2. Processing and quality of personal data. Section 1. Processing of personal data. Article 4. Authorization to process personal data. Article 5. Privacy of the data subject. Article 6. Consent of the data subject. Article 7. Indication of other matters in the declaration of consent. Article 8. Right of the data subject to withdraw his or her consent. Article 9. Processing a child's personal data. Article 10. Grounds for processing sensitive personal data. Article 11. Safeguards to process sensitive personal data. Article 12. Processing personal data of a convict. Article 13. Processing of personal data which does not require data subject's identification. Article 14. Source of personal data. Section 2. Quality of personal data and record of personal data. Article 15. Quality of personal data. Article 16. Personal data logging. Article 17. Maintaining records of processed personal data. Chapter 3. Right of the data subject. Article 18. Right to personal data. Article 19. Right to object. Article 20. Right to personal data portability. Article 21. Right not to be subject to a decision based on automated data processing. Article 22. Right to restriction of processing of personal data. Article 23. Right to erasure of personal data. Article 24. Right to rectification. Article 25. Right to designate an heir to personal data. Article 26. Right to representation. Chapter 6. Tasks and powers of the supervisory authority in matters relating to the protection of personal data and privacy. Article 27. Duties of the supervisory authorities in matter of relating to the protection of personal data and privacy. Article 28. Powers of the supervisory authority in matters relating to the protection of personal data and privacy. Chapter 5. Registration of a data controller and data processor. Article 29. Registration as a data controller or a data processor. Article 30. Requirements for registration as a data controller or a data processor. Article 31. Issuance of a registration certificate. Article 32. Reporting a change after receiving a registration certificate. Article 33. Renewal of a registration certificate. Article 34. Modification of a registration certificate. Article 35. Cancellation of a registration certificate. Article 36. Register of a data controller and data processors. Chapter 6. Obligation of the data controller and the data processor. Principles relating to the processing of personal data. Article 38. Duties of the data controller and the data processor. Article 39. Designation of a representative of the data controller or the data processor. Article 40. Designation of the personal data protection officer. Article 41. Duties of the personal data protection officer. Article 42. Information to be provided during personal data collection. Article 43. Notification of a personal data breach. Article 44. Report on personal data breach. Article 45. Communication of a personal data breach to the data subject. Article 46. Lawful processing of personal data. Article 47. Measure to ensure security of personal data. Chapter 7. Sharing, transfer, storage, and retention of personal data. Article 48. Sharing and transfer of personal data outside Rwanda. Article 49. Contract for transfer of personal data. Article 50. Storage of personal data. Article 51. Migration and management of personal data after change or closure of business. Article 52. Retention of personal data. Chapter 8. Misconduct, offenses, and sanctions. Section 1. Administrative misconduct and sanctions. Article 53. Administrative misconducts. Article 54. Filing an application to the court. Article 55. Place where the administrative fine is deposited. Section 2. Offenses and penalties. Article 56. Accessing, collecting, using, offering, sharing, transfer, or disclosing of personal data in a way that is contrary to this law. Article 57. Re-identification of de-identified personal data in a way that is contrary to this law. Article 58. Destruction, erasure, concealment, or alteration of personal data in a way that is contrary to this law. Article 59. Sale of personal data in a way that is contrary to this law. Article 60. Collecting or processing of sensitive personal data in a way that is contrary to this law. Article 61. Providing false information. Article 62. Punishment of a corporate body or a legal entity. Article 63. Additional penalties. Chapter 9. Miscellaneous transitional and final provisions. Article 64. Organ in charge of settlement of disputes. Article 65. Right to claim for compensation. Article 66. Power to put in place regulations. Article 67. Transitional period. Article 68. Drafting, consideration, and adoption of this law. Article 69. Repealing provision. Article 70. Commencement. Law number 058/2021 or 13th of October 2021 relating to the protection of personal data and privacy. We, Kagame Paul, President of the Republic. The Parliament has adopted and we sanction, promulgate the following law and order it to be published in the official Gazette of the Republic of Rwanda. The Parliament. The Chamber of Deputies in its sitting of 12th August 2021, pursuant to the Constitution of the Republic of Rwanda of 2003, revised in 2015, especially in Article 23, 64, 69, 70, 88, 90, 91, 93, 106, 120, 122, and 176, pursuant to the African Union Convention on Cybersecurity and the Personal Data Protection adopted in Malabo, Equatorial Guinea on 27th June 2014, ratified by Presidential Order Number 104/01 of 18th September 2019, adopts. Chapter 1. General Provisions. Purpose of this law. This law aims at the protection of personal data and privacy and determines their processing. Article 2. Scope of this law. This law applies to, first, the processing of personal data by electronic or other means using personal data through an automated or non-automated platform. Second, the data controller, the data processor, or third party who is established or resides in Rwanda and processes personal data while in Rwanda, is neither established nor resides in Rwanda, but processes personal data of data subject located in Rwanda. Article 3. Definitions. In this law, the following terms have the following meanings. Personal data. Any information relating to an identified or identifiable natural person who can be identified directly or indirectly, in particular by reference to an identifier such as name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, psychological, genetic, mental, economic, cultural, or social identity of that natural person. Sensitive personal data information revealing a person's race, health status, criminal records, medical records, social origin, religious or philosophical beliefs, political opinion, genetic or biometric information, sexual life, or family details. 3. Encryption. Technical method used to render the content of data unreadable to any person who is not authorized to access it. 4. Processing of personal data. An operation or set of operation which is performed on personal data or on set of personal data, whether or not by automated means such as access to obtaining, collection, recording, structuring, storage, adaptation, or alteration, retrieval, reconstruction, concealment, consultation, use, disclosure by transmission, sharing, transfer, or otherwise making available, sale, restriction, erasure, or destruction. 5. Register of personal data controllers and data processors, a system of record, physical or electronic, of registered data controllers and data processors. 6. Privacy, a fundamental right of a person to decide who can access his or her personal data, when, where, why, and how his or her personal data can be accessed. 7. Significant consequences, effects that are as similarly significant in their impact as legal effect and that adversely affect a data subject's behavior or choices. 8. Legal consequences, effects that adversely affect a person's legal status or his/her legal rights. 9. Tokenization, the process of replacing sensitive data with unique identification symbols that retain all the essential information about the data without compromising its security. 10. Vital interest, interest linked to life or death of data subject. 11. Profiling, form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze and predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interest, reliability, behavior, location, or movements. Personal data logging, the process of recording personal data processing activities over a period of time for the purpose of event monitoring and auditing in an automated processing system. Personal data breach, a breach of personal data security leading to unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. Pseudonymization, the processing of personal data in such a manner that the data can no longer be attributed to a specific data subject without the use of additional information kept separately. 15. Data subject, a natural person from whom or in respect of whom personal data has been requested and processed. Recipient, a natural person, a public or private corporation, corporate body or legal entity to which the personal data are disclosed. User, a natural person, a public or private corporate body or a legal entity who uses or who requests personal data processing service. Consent of the data subject, freely giving specific, informed, and unambiguous indication of the data subject's wish by which he or she, by an oral, written, or electronic statement, or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Data controller. 19. Natural person, public or private corporate body or legal entity which alone or jointly with others processes personal data and determines the means of their processing. 20. Person, natural person, corporate body, or legal entity. 21. Third party, natural person, corporate body, or legal entity other than the data subject, the data controller, the data processor, and persons who, under the authority of the data controller, are authorized to process personal data. 22. Competent authority, sectoral authority responsible for overseeing sector-specific compliance in conjunction with the supervisory authority. 23. Supervisory authority, a public authority in charge of cybersecurity. Data processor. 24. Natural person, public or private corporate body or legal entity which is authorized to process personal data on behalf of the data controller. Chapter 2. Processing and quality of personal data. Section 1. Processing of personal data. Article 4. Authorization to process personal data. The processing of personal data carried out by the data processor is governed by a written contract between the data processor and the data controller. The data processor processes personal data on behalf of the data controller, subject to a written contract referred to in paragraph 1 of this article. The data controller authorizes the data processor, who provides sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing meets the requirements of this law. Article 5. Privacy of the data subject. The data controller, the data processor, or a third party processes personal data in a manner which does not infringe on the privacy of the data subject. Article 6. Consent of the data subject. Where the processing of personal data is based on the consent of the data subject demonstrates that he or she has consented to the processing of his or her personal data for a specific purpose. The consent of the data subject is valid only when it is based on the data subject's free decision after being informed of the consequences of his or her consent. The consent of the data subject may be made in oral, written, or electronic form. Article 7. Identification of other matters in the declaration of consent. The data subject declaration of consent that contains other matters must clearly indicate that those other matters to which he or she consents in one of the official language that is understandable to him or her. Any part of the declaration referred to in paragraph 1 of this article which constitutes an infringement of the provision of this law cannot be binding. Article 8. Right of the data subject to withdraw his or her consent. The data subject has the right to withdraw his or her consent at any time. The withdrawal of the consent of the data subject does not affect the lawfulness of processing of personal data based on consent before its withdrawal. The withdrawal of the consent by the data subject is as easy as expressing it. The withdrawal of the consent by data subject takes effect as of the date on which the data subject applies for it. Processing a child's personal data. Where the data controller, the data processor, or a third party knows that personal data belongs to a child under the age of 16 years, he or she must obtain consent of holder of parental responsibility over the child in accordance with the relevant laws. Subject to the provision of other laws, the consent obtained on behalf of the child is acceptable only if it is given in the interest of the child. However, the consent is not required to process the child's personal data if it is necessary for protecting the vital interests of the child. Article 10. Grounds for processing sensitive personal data. The data controller or the data processor processes sensitive personal data only if the processing is based on the data subject's consent. The processing is necessary for the purpose of carrying out the obligation of the data controller or the data processor or exercising specific right of the data subject in accordance with the relevant laws. The processing is necessary to protect the vital interest of the data subject or of any other person. The processing is necessary for the purpose of preventive or occupational medicine, public health, such as protecting against serious cross-border threat to health or ensuring a high standard of quality and safety of health care and of medicinal products or medical devices. The processing is necessary for achieving purposes in the public interest or scientific and historical research purposes or statistical purposes. Article 11, safeguards to process sensitive personal data. When processing sensitive personal data, the data controller or the data processor must first comply with the requirement for personal data protection or personal data monitoring as required by this law. 2. Comply with applicable sensitive personal data retention period established by this law. 3. Put in place measures to strengthen the capacities of staff involved in the processing of sensitive personal data. 4. Put in place measures to access sensitive personal data processed by the data controller or the data processor. 5. Implement appropriate technical and organizational measures to ensure a level of security appropriate to the risks posed by the data subject, including where appropriate storing sensitive personal data separately from other types of data and applying measures such as tokenization, pseudonymization, or encryption. Article 12. Processing personal data of a convict. Processing personal data of a convict is carried out under the supervision of the supervisory authority in accordance with the provision of this law. The data controller or the data processor puts in place appropriate safeguards to ensure the respect of rights and freedoms of the data subject. Article 13. Processing of personal data which does not require data subject's identification. If the purpose for which the data controller or the data processor processes personal data do not or no longer require the identification of the data subject, the data controller or the data processor is not obliged to maintain, acquire, or process additional information in order to identify the data subject for the sole purpose of complying with this law. In case the data controller or the data processor is unable to identify the data subject because of the alteration of his or her personal data, the data controller informs the data subject in writing or electronically if necessary. However, the data subject with respect to this or her right provide additional information, enabling his or her identification. Article 14. Source of personal data. The data controller or the data processor requests personal data directly from the data subject. However, a person can collect personal data from another person, another source, or a public institution if the personal data is open to the public, the data subject has deliberately made the personal data public, the data subject has consented to the collection of personal data from another source, the collection of the personal data from another source complies with the law, with the provision of this law. Repeat. Source of personal data. The data controller or the data processor requests personal data directly from the data subject. However, a person can collect personal data from another person, another source, or a public institution if 1. The personal data is open to the public. The data subject has deliberately made the personal data public. The data subject has consented to the collection of personal data from other sources. The collection of the personal data from another source complies with the provision of this law. Section 2. Quality of personal data and records of personal data. Article 15. Quality of personal data. The data controller or the data processor ensures that the personal data is complete, accurate, kept up to date, and not misleading, having regard to the purpose for which they are processed. Article 16. Personal data logging. The data controller or data processor ensures personal data logging at least on the following data operations: data collected, data altered, data accessed, data disclosed including data sharing and transfer, combined data, erased data. Personal data logging must indicate justification date and time of such operation and where possible the contact details of the person who accessed or disclosed the personal data as well as the contact details of the recipient of the data. The supervisory authority may require the data controller or the data processor to provide access to the personal data logging so as to verify the lawfulness of the personal data processing. Article 17. Maintaining record of processed personal data. The data controller or the data processor must maintain a record of all personal data processing activities under his or her responsibility that indicates the name and contact details of the data controller and, where applicable, the data processor, the controller's representative, or the protection officer. The purpose of the processing of personal data, a description of the categories of data subject and of the category of personal data, a full list of the recipients to whom personal data have been or will be disclosed, including those based in other countries, a description of transfer of personal data to any country outside Rwanda, where possible the envisaged data retention period for the different categories of personal data. The data controller or the data processor submits the records of personal data processing activities to the supervisory authority on requests. Chapter 3. Rights of the data subject. Article 18. Right to personal data. Without prejudice to other relevant law, the data subject may, in writing or electronically, request from the data controller or the data processor the following. 1. To provide him or her with the information relating to the purpose of the processing of personal data. 2. To provide him or her with a copy of personal data. 3. To provide him or her with a description of personal data that the data controller or the data processor holds, including data on the contact details of a third party or the categories of third parties who have or had access to the personal data. 4. To inform him or her of the source of the personal data in case his or her personal data have not been obtained from the data subject. To inform him or her in case his or her personal data have been transferred to a third country or to an international organization. The right referred to in item 2 of paragraph 1 of this article is not exercised if it may adversely affect the rights and freedoms of other persons. Second, legal, professional privilege or other legal obligation of confidentiality apply. 3. The data relates to information management or information about the data subject, or relates to ongoing negotiation with the data subject's requester. The data relates to the data subject confidential references, examination script, or examination marks. The data controller or the data processor must provide the data subject with his or her personal data in a clear and concise manner. The data subject who is not satisfied with the response of the data controller or the data processor may appeal to the supervisory authority within 30 days from the date of receipt of the response. If the data subject appeals, the supervisory authority responds to his or her appeal within 60 days from the date of the receipt of the appeal. Article 9. Right to object. The data subject at any time in writing or electronically may request the data controller or the data processor to stop processing his or her personal data which causes or is likely to cause loss, sadness, or anxiety to the data subject. However, this right does not apply if the data controller or the data processor demonstrate compelling legitimate grounds for the personal data processing which override the interest, right, and freedoms of the data subject, or for the establishment of the legal claim. The data subject at any time in writing or electronically may request the data controller or the data processor to stop processing personal data of the data subject if personal data are processed for direct marketing purposes, including profiling to the extent that is related to such direct marketing. The data controller or the data processor within 30 days from the date of receipt of the request must inform the concerned data subject in writing or electronically of the compliance with the request or reasons for non-compliance. The data subject who is not satisfied with the response of the data controller or the data processor may appeal to the supervisory authority within 30 days from the date of the receipt of the response. If the data subject appeals, the supervisory authority respond to his or her appeal within 60 days from the date of the receipt of the appeal. Right to personal data portability. The data subject has the right to request the data controller in writing or electronically to resend the personal data concerning him or her as it was provided to the data controller in a structured and readable format. The data subject also has the right to request the data controller in writing or electronically to have his or her personal data transmitted to another data controller where technically feasible without hindrance. The data controller within 30 days from the date of the receipt of the request must inform the concerned data subject in writing or electronically of personal data portability. The data subject who is not satisfied with the response of the data controller may appeal to the supervisory authority within 30 days from the date of the receipt of the response. If the data subject appeals, the supervisory authority responds to his or her appeal within 60 days from the date of the receipt of their appeal. Article 21. Right not to be subject to a decision based on automated data processing. The data subject has the right not to be subject to a decision based solely on automated personal data processing, including profiling, which may produce legal consequences, significant consequences to him or her. However, the provision of paragraph 1 of this article does not apply if the decision, first, is based on the data subject explicit consent, second, is necessary for entering into or performance of a contract between the data subject and the data controller, 3, is authorized by laws to which the data controller is subject and also puts in place sustainable measures to safeguard the data subject's rights, freedoms, and legitimate interests. Any automated processing of personal data intended to evaluate certain personal aspects relating to a natural person does not base on sensitive personal data unless one of the grounds set out in Article 10 of this law is met. Article 22. Right to restriction of processing of personal data. The data subject or the supervisory authorities has the right to restrict the data controller from processing personal data for a given period if, first, the accuracy of a personal data is contested by the data subject pending the verification of the accuracy. Second, the processing is unlawful and the data subject requests the erasure of the personal data or the restriction of the use of some of them. 3. The data subject has objected to the processing of personal data pending the verification whether the legitimate ground of the controller overrides those of the subject. The right to restriction of processing of personal data described in paragraph 1 of the article is not exercised if the processing of personal data, first, is necessary for the protection of the right of another person. Second, is necessary for reasons of public interest. The data controller must, before lifting the restriction of processing of personal data referred to in item 1st of paragraph 2 of this article, inform the data subject in writing or electronically. Article 23. Right to erasure of personal data. The data subject has the right to request the data controller in writing or electronically for erasure of his or her personal data where, first, the personal data are no longer necessary in relation to the purpose for which they were collected or processed. Second, the data subject withdraws consent on which the personal data processing is based and where there is no other legal ground for the processing. Third, the data subject objects to the processing of personal data and there are no overriding legitimate ground for the processing. Fourth, the personal data have been unlawfully processed. The data controller who has disclosed personal data to a third party or has posted the personal data in the public domain must, in writing or electronically, inform a third party processing such data that the data subject has requested the erasure of any links to or copy of those personal data. However, the right to request the erasure of personal data does not apply to the extent that processing is necessary. First, for reasons of public interest. Second, for historical or scientific research purposes or statistical purposes. Third, for compliance with a legal obligation to which the controller is subject or for the performance of a task carried out in the public interest or in the exercise of official authority vested in the data controller. Fourth, for the establishment, exercise, or defense of legal claims in the interest of the data controller. The data controller, within 30 days from the date of receipt of the request, must inform the concerned data subject in writing or electronically of the erasure of his or her personal data. The data subject who is not satisfied with the response of the data controller may appeal the supervisory authority within 30 days from the date of the receipt of the response. If the data subject appeals, the supervisory authority responds to this appeal to his or her appeal within 60 days from the date of the receipt of the appeal. Article 24, right to rectification. The data subject has the right to request the data controller for the rectification of his or her personal data. The data subject has the right to have incomplete personal data completed where necessary. The data controller, within 30 days from the date of the receipt of the request, must inform the data subject in writing or electronically of the rectification of his or her personal data. The data subject who is not satisfied with the response of the data controller may appeal to the supervisory authority within 30 days from the date of the receipt of the response. If the data subject appeals to the supervisory authority, respond to his or her appeal within 60 days from the date of the receipt of the appeal. Article 25. Right to designate an heir to personal data. The personal data of the data subject are not subject to succession. However, where the data subject had left a will, that data subject provides his or her heir with full or restricted rights relating to the processing of personal data kept by the data controller or the data processor if such personal data still needs to be used. Article 26, right to representation. The right of the data subject to representation is exercised where, first, the data subject is under 16 years of age, in which case he or she is represented by a person who has parental authority over him or her, or who was appointed as his or her guardian. Second, the data subject has a physical impairment and is unable to represent himself or herself, in which case he or she is represented by his or her parent, adopter, or a center or association that caters for him or her guardian appointed by a court. Third, the data subject has a medical determinable mental impairment and is unable to represent himself or herself, in which case he or she is represented by his or her parent, adopters, a center or an association that caters for him or her, or the guardian appointed by a court. Fourth, there is any other reason in which case he or she is represented by another person authorized in writing by the data subject in accordance with relevant law. Chapter 4. Duties and powers of the supervisory authorities in matters relating to protection of personal data and privacy. Article 27. Duties of the supervisory authority in matters relating to the protection of personal data and privacy. The supervisory authority has the following duties. First, to oversee the implementation of this law. Second, to respond to every legitimate request for an opinion regarding personal data processing. Third, to inform the data subject, the data controller, the data processor, and the third party of their right and obligation. Fourth, to put in place a register of data controllers and data processors. 5. To investigate the subject matter of the complaint lodged by the data subject, the data controller, the data processor, or a third party relating to the processing of personal data and information, and inform them of the outcome of the investigation within a reasonable period. 6th, to receive and consider the data subject's appeal. 7th, to advise on matter relating to protection of personal data and privacy. 8th, cooperate with authorities, organizations, and entities operating within the country or abroad in the protection of personal data and privacy. Article 28. Powers of the supervisory authorities in matter relating to the protection of personal data and privacy. The supervisory authority has powers to, first, to issue a registration certificate as provided for by this law. Ensure that the processing of personal data is consistent with the provisions of this law. Third, ensure that information and communication technologies do not constitute a threat to public freedoms and the privacy of a person. Fourth, to put in place a regulation relating to the application of this law. Fifth, to impose administrative sanctions in accordance to the provisions of this law. Chapter 5. Registration of the data controller and the data processor. Article 29. Registration as a data controller or a data processor. A person who intends to be a data controller or a data processor must register with the supervisory authority. Article 30. Requirement for registration as a data controller or a data processor. An applicant for registration as a data controller or data processor must indicate the following. First, his or her identity and his or her designated single point of contact. Second, the identity and address of his or her representative if he or she has nominated any. Third, a description of personal data to be processed and a category of the data subject. Fourth, whether or not the application holds or is likely to hold the types of personal data based on the sectors in which it operates. Fifth, the purposes of the processing of personal data. Sixth, the categories of recipient to whom the data controller or the data processor intends to disclose the personal data. Seventh, the country to which the applicant intends to directly or indirectly transfer the personal data. Eighth, risks in processing of personal data and measures to prevent such risks and protect personal data. The supervisory authority may put in place a regulation determining additional requirements to be met by an applicant for the registration as a data controller or a data processor. Article 31. Issuance of a registration certificate. The supervisory authority issues a registration certificate to an applicant for registration as a data controller or a data processor who meets the requirements for registration within 30 working days from the date of reception of the registration application. The supervisory authority puts in place a regulation determining the period of validity of the registration certificate. Article 32. Reporting a change after receiving a registration certificate. After receiving a registration certificate, if there is a change in the grounds of which the registration certificate was issued, the data controller or the data processor who received it notifies the supervisory authority in writing electronically within 15 working days from the date on which such a change occurred. The supervisory authority, as soon as it's informed or change referred to under paragraph 1 of this article and gives it a satisfactory update on the information. Article 33. Renewal of a registration certificate. The data controller or the data processor who holds a registration certificate may apply for its renewal within 45 working days before the expiry date of the existing certificate. The supervisory authority responds in writing or electronically to the application referred to under paragraph 1 of this article within 30 working days following receipt of the application. The supervisory authority puts in place a regulation determining requirements for renewal of the registration certificate. Article 34. Modification of a registration certificate. The supervisory authority, on its own motion or request by the registration certificate holder, may modify the registration certificate before its expiry if the supervisory authority believes that the modification is needed to respond on: first, change that occurred on applicable laws; second, a change in the information that he or she provided that may affect the registration certificate. Article 35. Cancellation of a registration certificate. The supervisory authority may cancel the registration certificate before its date of expiry if the registration certificate holder, first, has submitted false or misleading information; second, fails to comply with requirements of this law or terms and conditions specified in the certificate. Before cancellation of the registration certificate, the supervisory authority provides the certificate holder with 15 working days prior notice in writing electronically requesting for an explanation or non-compliance with provisions of paragraph 1 of this article. Article 36. Register of data controllers and data processors. The supervisory authority puts in place A register of data controllers and data processors such as a register is kept and managed by the supervisory authority, which also determines its forms and the manner in which it is used. The supervisory authority may, at the request of the data controller or the data processor who has an outdated entry in the registry of data controllers and data processors, erase the entry from the register. The supervisory authority puts in place a regulation determining modalities under which persons with justified reasons may have the right of access to register of a data controller and data processor for consultation, or to be issued with a certificate copy or an extract of any entry in such a register. Chapter 6. Obligations of the data controller and the data processor. Article 37. Principles relating to processing of personal data. The data controller and the data processor ensure that the data subject's personal data, first, are processed lawfully, fairly, and in transparent manner. Second, are collected for explicit, specified, and legitimate purposes, and not further processed in a manner incompatible with those purposes. Third, are related to the purpose for which their processing was requested. Fourth, are accurate and where necessary kept up to date with every reasonable step being taken to ensure that any inaccurate personal data are erased and rectified without delay. Fifth, are kept in a form which permits identification of data subject for no longer than is necessary for the purpose for which the personal data are processed. Sixth, are processed in compliance with the rights of the data subject. Article 38. Duties of the data controller and the data processor. In compliance with the principles of the processing of personal data, the data controller and the data processor discharge the following duties. First, to implement appropriate technical and organizational measures. Second, to keep a record of personal data processing operations. Third, to carry out personal data protection impact assessment where the processing of personal data is likely to result in a high risk to the right and freedoms of a natural person. Fourth, to perform such other duty as may be assigned to him or her by supervisory authority. The personal data protection impact assessment referred to in item 3 of paragraph 1 of this article is carried out in case of, first, a systematic and extensive evaluation of a personal aspect relating to the natural person, which is based on automated processing of personal data, including profiling, and on which decisions that produce effect concerning such persons are based. Second, processing on a large scale of sensitive personal data. Third, a systematic monitoring of a publicly accessible area on a large scale. Fourth, processing of personal data identified by the supervisory authority as likely to result in a high risk to the rights and freedoms of a natural person. Fifth, new technologies used to process personal data. Article 39. Designation of a representative of the data controller. The data controller or the data processor who is neither established nor resides in Rwanda but processes personal data of data subject located in Rwanda designates in writing a representative in Rwanda to comply with his or her obligations under its law. The supervisory authority puts in place a regulation governing the designation of representative of the data controller or data processor. Article 40. Designation of personal data protection officer. The data controller and the data processor designate a data protection officer where, first, the processing of personal data is carried out by public or private corporate body or a legal entity except courts. Second, the core activities of the data controller or the data processor consist of personal data processing operations which, by virtue of their nature, their scope, and their purpose, require regular and systematic monitoring of data subjects on a large scale. Third, the core activities of the data controller or the data processor consist of processing on a large scale of specific categories of data apportioned to Article 10 of this law and personal data relating to criminal convictions referred to in Article 12 of this law. A group of undertakings may be appointed may appoint a single personal data protection officer, provided that the data protection officer is easily accessible from each establishment. Where the data controller or the data processor is a public authority or body, a single personal data protection officer may be designated for several such authorities or bodies, taking account of the organizational nature and size. In case other than those referred to in paragraph 1 of this article, the data controller or the data processor associations and other bodies representing categories of the data controller or data processor may designate a personal data protection officer in accordance with the provisions of this law. The data protection officer is designated on the basis of professional qualities, expert knowledge of personal data protection practices, and the ability to fulfill the tasks assigned to him or her. The personal data protection officer may be a permanent staff member of the data controller or the data processor, or a person who fulfills the task on a basis of service contract. The data controller or the data processor must publish the contact details of the personal data protection officer and communicate them to the supervisory authority. Article 41. Duties of the personal data protection officer. The personal data protection officer has the following duties: to inform and advise the data controller, the data processor, and the employees who carry out personal data processing of the obligation pursuant to this law; to monitor in his or her area of work compliance with this law and with the policies of the data controller or data processor in relation to the protection of personal data, including the assignment of responsibilities, awareness raising, and training of staff involved in personal data processing operations and the related audits; to provide advice where requested as regards to the data protection impact assessment and monitor its performance; to cooperate with the supervisory authority and to act as its contact point in issues relating to the processing of personal data, including the prior consultation with the supervisory authority, and to consult where appropriate with regard to any other matter. The personal data protection officer must, in the performance of his or her tasks, have due regard to the risk associated with personal data processing operations, considering the nature, scope, and context and purpose of the processing. Article 42. Information to be provided during the personal data collection. The data controller collects personal data for a lawful purpose connected to the activities of the data controller when the data is necessary for that purpose. The data controller who collects personal data informs the data subject of the following: his or her identity and contact details, the purpose for which the personal data are collected, recipient of such personal data, whether the data subject has the right to provide personal data voluntarily or mandatorily. Fifth, the existence of the right to withdraw consent at any time, and that such withdrawal does not affect the lawfulness of the processing of the personal data based on the consent before its withdrawal. Sixth, the existence of the right to request from the data controller to access and rectification restriction or erasure from personal data concerning the data subject or to object of processing of the data. 7. The existence of automated decision-making, including profiling and information about the logic involved, as well as the significance and the invasive consequences of such processing personal data for the data subject. 8. The period for which personal data will be stored. 9. The right to appeal to the supervisory authority. 10. Where applicable, that he or she can transfer personal data outside Rwanda if he or she assures him or her of their security. 11. Any further information likely to guarantee fair processing of the personal data having regards to the specific circumstances in which the data are collected. However, the data controller is not required to comply with provision of paragraph 2 of the article if the data subject already has the information referred to in paragraph 1 of this article, the supervision of such information proves impossible or involves a disproportionate effort, the recording or disclosure of the personal data is provided for by the law. Article 43. Notification of personal data breach. In case of a personal data breach, the data controller within 48 hours after being aware of the incident must communicate the personal data breach to the supervisory authority. Where the data processor becomes aware of personal data breach, he or she notifies the data controller within 48 hours after being aware of the incident. Article 44, report on personal data breach. The data controller draws up a report on personal data breach and submits it to the supervisory authority not later than 72 hours with all facts available. The report describes at least the nature of the personal data breach, including where possible the category and approximate number of data subjects concerned, and the categories and approximate number of personal data records concerned, the contact details of the personal data protection officer or other contact point where more information can be obtained, the measures taken to address the personal data breach, including measures to mitigate, if possible, adverse effects. The acts relating to personal data breach, the consequence of the personal data breach, and the measures taken to rectify such a breach. His or her proposal for communicating the personal data breach to affected data subject and a timeline for such a communication for approval by the supervisory authority. Article 45, communication of a personal data breach to the data subject. Where the personal data breach is likely to result in a high risk to the rights and freedoms of the data subject, the data controller communicates the personal data breach to the data subject in writing or electronically after having become aware of it. However, the data controller is not required to communicate the personal data breach to the data subject if the data controller has implemented appropriate technical and organizational protection measures in relation to the data breach such that the personal data breach is unlikely to result in a high risk to the rights and freedoms of the data subject. 2. The data controller has taken measures which ensures that the high risk to the rights and freedoms of the data subject is no longer likely to materialize. The data controller communicated to the public whereby the data subject is informed in an equally effective manner. If the data controller has not communicated the personal data breach to the data subject and the personal data breach is likely to result in a high risk to the rights of and the freedoms of the data subject, the supervisory authority may request the data controller to communicate the personal data breach to the data subject in writing or electronically. Lawful processing of personal data. The data controller or the data processor lawfully processes personal data if, first, the data subject has given consent to the processing of his or her personal data for purposes explained to him or her. Second, processing is necessary for the performance of a contract to which the data subject is party or in order to take steps at the request of the data subject prior to entering into a contract. Third, the data controller executes a legal obligation to which he or she is subject. 4. It is necessary for protection of vital interests of the data subject or any other person. 5th, it is necessary for the performance of a duty carried out in the public interest or in the exercise of official authority vested in the data controller. 6th, it is carried out for the performance of duties of a public entity. 7th, it is intended for legitimate interest pursued by the data controller or by a third party to whom the personal data are disclosed, unless the processing of personal data is unwarranted in any particular case having regard to the prejudice to the rights and freedoms or legitimate interest pursued by the data subject. 8. It is carried out for research purposes upon authorization by relevant institutions. Article 47. Measures to ensure security of a personal data. The data controller or the data processor must ensure security of personal data in his or her possession by adopting appropriate reasonable technical measures to prevent loss, damage, destruction of personal data. For purpose of enforcing the provision of paragraph 1 of this article, the data controller or the data processor takes the following measures to ensure security of the personal data. Identify foreseeable risks to personal data under the person's possession or control, establish and maintain appropriate safeguards against those risks. Second, regularly verify whether the personal data security safeguards are effectively implemented. Third, Ensure that the personal data security safeguards are continually updated in response to the new risks or any identified deficiencies. When the supervisory authority is of the opinion that processing or transferring personal data may infringe the rights and privacy of the data subject, the supervisory authority conducts an inspection and assessment of the measures set out in this article. Chapter 6: Sharing, Transfer, Storage, and Retention of Personal Data. Article 48: Sharing and transfer of personal data outside Rwanda. The data controller or the data processor may share or transfer personal data to a third party outside Rwanda if he or she has obtained authorization for the supervisory authority after providing proof of appropriate safeguard with respect to the protection of personal data. Second, the data subject has given his or her consent. Third, the transfer is necessary A. for the performance of a contract between the data subject and the data controller or the implementation of a pre-contractual measures taken in response to the data subject's request. B. for the performance of a contract concluded in the interest of the data subject between the data controller and the third party. C. for public interest ground. D. for the establishment, exercise, or defense of a legal claim. E. to protect the vital interests of the data subject or of other person where the data subject is physically or legally incapable of giving his or her consent. F. for the purpose of compelling legitimate interests pursued by the data controller or by the data processor which are not overridden by the interests, rights, and freedoms of the data subject, and when I. the transfer is not repetitive and concerned only a limited number of data subjects. To II. the data controller or the data processor has assessed all of the circumstances surrounding the data transfer and has, on the basis of that assessment, provided suitable safeguards with regard to the protection of personal data. G. for the performance of international instruments ratified by Rwanda. The supervisory authority may put in place a regulation determining another reason of sharing or transferring personal data to a third party outside Rwanda. Article 49: Contract for transfer of personal data. The data controller or the data processor who authorizes a person to access personal data, share, or transfer them to a third party outside Rwanda enters into a written contract with such a person, setting out the respective roles and responsibilities of each party to ensure compliance with this law. The supervisory authority may, by regulation, determine the form of the contract to be used for transfer of personal data outside Rwanda. Provision of item 1st and 3rd, A, B, and D of the Article 48 of this law does not apply to activities carried out by a public body in the exercise of its functions. The supervisory authority may require the data controller or the data processor to demonstrate their compliance with the provision of this article, and in particular with the personal data security safeguard and interest referred to in item 3, 3rd F of Article 48 of this law. The supervisory authority, in order to protect the rights and freedom of the data subject, may prohibit or suspend the transfer of personal data outside Rwanda. Article 50. Storage of personal data. The data controller or the data processor stores personal data in Rwanda. However, the storage of personal data outside Rwanda is only permitted if the data controller or data processor holds a valid registration certificate authorizing him or her to store personal data outside Rwanda, which is issued by the supervisory authority. Article 51. Migration and management of personal data after a change or closure of business. The supervisory authority puts in place a regulation determining modalities for migration and management of personal data in case of change or closure of business of the data controller or the data processor. Article 52. Retention of personal data. The data controller or the data processor retains personal data until the purpose of the processing of the personal data are fulfilled. However, the data controller or the data processor may retain personal data for a longer period of the following ground: if retention is authorized by law, if retention is required by a contract concluded between the parties, if the personal data is related to a function or activity for which the personal data are collected or processed. Fourth, preventing, detecting, investigating, prosecuting, and punishing an offender. Fifth, protecting national security. Sixth, enforcing a court order. Seventh, enforcing legislation relating to collection of public revenues. 8. Conducting proceedings before a court. 9th, carrying out research authorized by a relevant authority. 10th, if the data subject consents. The supervisory authority may put in place a regulation determining any other ground for retention of personal data for a longer period. At the end of the personal data retention period, the data controller and the data processor must destroy the personal data in a manner that prevents its reconstruction in an intelligible form. Chapter 8. Misconducts, Offenses and Sanctions. Section 1. Administrative misconduct and sanction. Article 53. Administrative misconduct. The data controller, the data processor, or a third party who commits one of the following misconduct: failure to maintain record of processed personal data, failure to carry out personal data logging, operating without a registration certificate, failure to report a change after receiving a registration certificate. 5th, using a certificate whose terms of validity has expired. 6th, failure to designate a personal data protection officer. 7th, failure to notify a personal data breach. 8. Failure to make a report on personal data breach. 9. Failure to communicate a personal data breach of the data subject. 2. The data subject commits a misconduct. He or she is liable to administrative fine of not less than 2 million Rwandan francs, but not more than 5 million Rwandan francs, or 1% of the global turnover of the preceding financial year. In the event of a corporate body or a legal entity, he or she is liable to 1% of the global turnover of the preceding financial year. The supervisory authority may put in place a regulation determining other administrative misconduct and sanctions that are provided for in this law. Article 54. Filing an application to the court. The data controller, the data processor, or a third party who is not satisfied with the administrative sanction taken against him or her has the right to file an application to the competent court. Article 55. Place where the administrative fine is deposited. The administrative fine is imposed by the supervisory authority is deposited to the public treasury. Section 2. Offenses and penalties. Article 56. Accessing, collecting, using, offering, sharing, transfer, or disclosing of personal data in a way that is contrary to this law. A person who accesses, collects, uses, offers, shares, transfers, or discloses personal data in a way that is contrary to this law commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 1 year, but no more than 3 years, and a fine not less than 7 million Rwandan francs, but not more than 10 million Rwandan francs, or one of these penalty. I repeat. Article 56. Accessing, collecting, using, offering, sharing, transfer, or disclosing of personal data in a way that is contrary to this law. A person who accesses, collects, uses, offers, shares, transfers, or discloses personal data in a way that is contrary to this law commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 1 year, but not more than 3 years, and a fine of not less than 7 million Rwandan francs, but not more than 10 million Rwandan francs, or one of these penalties. Re-identification of de-identified personal data in a way that is contrary to this law. Any person who knowingly, intentionally, or recklessly re-identifies personal data which have been de-identified by a data controller or data processor re-identifies and processes personal data without consent of the data controller commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 1 year, but not exceeding 3 years, and a fine of not less than 7 million Rwandan francs, but not more than 10 million Rwandan francs, or one of these penalties. destruction, erasure, concealment, or alteration of personal data in a way that is contrary to this law. A person who destroys, erases, conceals, or alters personal data in a way that is contrary to this law commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 3 years, but not more than 5 years, and a fine of not less than 7 million Rwandan francs, or one of these penalties. Sale of personal data in a way that is contrary to this law. A person who sells personal data in a way that is contrary to this law commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 5 years, but not more than 7 years, and a fine of not less than 12 million Rwandan francs, but not more than 15 million Rwandan francs, or one of these penalties. Article 60. Collecting or processing of sensitive personal data in a way that is contrary to this law. A person who collects or processes sensitive personal data in a way that is contrary to this law commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 7 years, but not more than 10 years, and a fine of not less than 20 million Rwandan francs, but not more than 25 million, or one of these penalties. Article 61. Providing false information. A person who provides false information during and after registration commits an offense. Upon conviction, he or she is liable to an imprisonment of not less than 1 year, but not more than 3 years, and a fine of not less than 3 million Rwandan francs, but not more than 5 million Rwandan francs, or one of these penalties. Article 62. Punishment of corporate body or legal entity. A corporate body or legal entity that commits one of these offenses referred to in Article 56, 7, 58, 59, 60, 61 commits an offense. Upon conviction, it is liable to a fine of Rwandan francs amounting to 5% of its annual turnover of the previous financial year. Additional penalties. In addition to penalties provided for in this law, the court in all cases may order the seizure or confiscation of items used in the commission of any offense provided for in this law and the proceeds gained. The court may also order permanent or temporary closure of the legal entity or body or the premise in which any of the offense provided for under this law was committed. Chapter 9. Miscellaneous. Transitional and final provision. Article 64. Organ in charge of settlement of conflict. The supervisory authority is the organ in charge of settlement of conflict that may arise in relation to this law. However, a person who is not satisfied with the settlement of the conflict referred to in paragraph 1 of this article may file a case with a competent court. Article 65. Right to claim for compensation. A person who suffers serious damage due to acts of data control of a data controller or data processor in violation of this law has the right to claim for compensation with a competent court. However, the data controller or the data processor is exempt from liability if he or she proves that he or she was not responsible for the damage. Article 66. Power to put in place regulation. The competent authority may, in conjunction with a supervisory authority, put in place other sector-specific regulation governing the protection of personal data and privacy. The regulation referred to in paragraph 1 of this article must comply with the provisions of this law. Article 67. Transitional period. The data controller or the data processor who is already in operation has a period not exceeding 2 years from the date of publication of this law in the official gazette of the Republic of Rwanda to conform his or her operation to the provisions of this law. Article 68. Drafting and consideration and adoption of this law. This law was drafted in English, considered and adopted in Kinyarwanda. Article 69. Repealing provision. All prior legal provision contrary to these laws are repealed. Article 70. Commencement. The law comes into force on the date of its publication in the official gazette of the Republic of Rwanda. Your Excellencies, President, Prime Minister, goodbye. Thank you for reading this law with us. See you on the flip side.